my lady, my lords, I was going to turn, first of all, to grounds 1 and 2, which are the Mozambique point. And it's important to be clear at the outset about the ambit of this non-justiciability point which is being advanced. It is not a partial attempt at a strikeout or anything of that nature. In previous cases, such as in Chugai, parties have made limited applications to strike out parts, in most cases limited parts, of claims or defences as being non-justiciable. There was certainly no suggestion in Chugai that the contractual claim could not proceed at all. The only question was whether Chugai could include its squeeze arguments as part of its case and explain why the US patent in that case would be invalid if construed in the manner suggested by UCB, and of course Mr. Justice Henry Carr found that it could. But by contrast, in this case, the contention advanced by GW Farmer is that because one of the points which it wishes conditionally to raise by way of defence to the contractual claim is the alleged invalidity of the patent which it jointly owns, a point which I note in parentheses is expressly, as we shall see, a point of last resort, all else fails, and which on numerous permutations may never arise at all. Nevertheless, they say, the entire claim pleaded by my clients becomes non-justiciable by the English courts and must simply cease forthwith. They say they are entitled, in effect, to torpedo the entire claim. And we say that is simply misconceived and wrong, and the High Court was quite right to reject it. On a proper analysis, none of the issues in this case, including GW Farmer's proposed defences, is barred by the Mozambique rule. And in that regard, I'm going to deal in turn with the relevant principles and then with their application to this case. The relevant principles are set out in paragraphs 32 to 43 of our skeleton argument. So that's core bundle, tab 5, page 58 onwards. In paragraph 33, we refer to what the Supreme Court said in Lucasfilm about all that there was left of the Mozambique rule. In 37, and I'll be taking you through these cases, but just to orient the court in the submissions I'll be making, 37 is the current formulation of the rule as approved by this court in Hamid. And then critically, for the purposes of my argument, the two elements of the rule are summarised at paragraph 43, that's page 60. And we submit, gathering the authorities together, that proceedings are only objectionable under the Mozambique rule if, firstly, they are principally concerned with, and that's the claim or proceedings as a whole, and thus raised directly as opposed to incidentally the validity of a foreign patent, and secondly, they are not based on a contract or equity between the parties. Those are the two conditions or elements of the Mozambique rule upon which we rely. And it's important to emphasise at this point that we are concerned here purely with a common law rule. There have been various references in argument to Brussels, but as my Lord Justice Burst rightly observed earlier, that no longer forms part of our law. There's no available objection under Brussels. The question is, what is the ambit of this common law rule? Now, with a view to making those two fundamental elements of the rule good, I shall take the court as quickly as I can through the cases, and I'll do so in chronological order, so we don't have to keep reopening them. I shall also deal with both elements at once. But what that means is that somewhat unusually, we need to consider the contractual exception first, because this is a case in which somewhat unusually, we have an exception that precedes the rule, because the contractual exception comes from Penn and Baltimore, which is in the Authorities Bundle at Authorities Bundle 1, tab 1. This was a case in which the plaintiff, Mr. Penn, asked the Chancery Division in London to give specific performance of an agreement settling the boundaries between the provinces of Pennsylvania and Maryland. The nature of the case was contractual, but it could hardly have impinged more upon foreign land outside the jurisdiction. And you can see from the headnote, the first paragraph, that the plaintiffs were Mr. Penn, who was the proprietor of Pennsylvania, and there's a reference to the 1732 Articles of Agreement ascertaining the boundaries between them. This first decision, just so the court knows where I'm going, decided only that the case should be adjourned so that the Attorney General could be a party. But there are some observations, even in this decision, on the question of jurisdiction. As the court will see in the middle of the page, between the hole punches, there's a paragraph beginning, "It was objected by the defendant." And the court will see that the second point that was taken was, secondly, that this was a case out of the jurisdiction of the court. So there was a jurisdictional point taken. And one then sees the court's observations at this point in the case, next to per curiam. Second line, the single point in this case is whether, as the matter stands, this court can decree a performance of these articles. There's then discussion of the jurisdictional position, and I pick up the analysis at the words "therefore questions," which are 10 lines up from the bottom. Therefore, questions between proprietary lords, in analogy to the ancient law of the marches, must be determined before the king in council, and always is so, notwithstanding a particular statute which restrains the power and jurisdiction of the Privy Council, semicolon, but a court of equity jurisdiction is in persona, and therefore can extend it wherever the parties' persons are within its jurisdiction. But here are, in this case, articles of agreement between the parties, and the sole question is whether a complete final decree could be made in this case without these parties before the court. So the court then decides that the Attorney General and other affected people need to be a party, and the matter comes back after a Dickensian delay of 5 years in tab 2. The matter came back before the court with the Attorney General and the other parties present. The key content of the articles in this case is summarised at the top of page 4 of the bundle, page 1133 of the report. In the 6th line, we can see, the 9th line, that they make a particular provision for settling them, that's the boundaries, by drawing part of a circle around the town of Newcastle, etc. A formula was agreed between the parties for determining the boundaries between the provinces. And one can see from the start of the next paragraph that the bill was for a specific performance and execution of the articles. Then we see in the, skipping forward 2 paragraphs, the first objection for the defendant was that this court has not jurisdiction nor ought to take recognisance of it, for that the jurisdiction is in the King and Council. So it was said this couldn't be decided by a court. Lord Hardwicke, the Lord Chancellor, begins his decision at the very bottom of that page. He says, "I directed this cause to stand over for judgment, not so much from any doubt as to what was the justice of the case, as by reason of the nature of it, the great consequence and importance, and the great labour and ability of the argument on both sides, it being for the determination of the right and boundaries of 2 great provincial governments and 3 counties of a nature worthy of the judicature of a Roman Senate rather than of a single judge, etc. He then considers the point of jurisdiction in the paragraph which begins first, which is 4 paragraphs down on that page. And in the 8th line of that paragraph, Lord Hardwicke says, "It is certain that the original jurisdiction in cases of this kind relating to boundaries between provinces, the dominion and proprietary government is in the King and Council." And there's then discussion of various cases about Wales and America and the such like. And then further down in that paragraph, just next to the lower hole punch, the court says, "This court therefore has no original jurisdiction on the direct question of the original right of the boundaries, and this bill does not stand in need of that. It is founded on articles executed in England under seal for mutual consideration, which gives jurisdiction to the King's courts, both of law and equity, whatever be the subject matter. An action of covenant could be brought in BR or CB if either side committed a breach. So might there be for the £5,000 penalty without going to the council. There are several cases wherein collaterally, and by reason of the contract of the parties, matters out of the jurisdiction of the court originally will be brought within it." So the court is saying that although a particular topic may lie outside the jurisdiction of the courts, nevertheless, an agreement between the parties may make it necessary for a court to decide it, at least collaterally, to use the word used by Lord Hardwicke. The same point is picked up towards the very end of the page, the last sentence on the page. "The conscience of the party was bound by this agreement, and being within the jurisdiction of this court, which acts in personam, the court may properly decree it as an agreement if a foundation for it. To go a step farther, as this court collaterally and in consequence of the agreement judges concerning matters not originally within its jurisdiction, it would decree a performance of articles of agreement to perform a sentence in the ecclesiastical court, just as a court of law would maintain an action for damages in breach of covenant." So we see both the collaterally or incidentally requirement and the contractual exception. Well, the boundaries were eventually settled in 1768, ending an 80-year dispute.
Just in time for the War of Independence.
Quite, yes. 7 years later, the American Revolution occurred. But fortunately for me, the principle established by the case has lasted rather longer than Mr. Penn or Lord Baltimore's tenure of the lands in question, because it remains a good law, as we'll be seeing from the authorities that I'll take the court through. So that's the foundation of the contractual exception. One then needs to turn to Mozambique, which is Authorities Bundle 1, Tab 3. Now, an important point about the Mozambique decision to make at the outset is that because the rule has been narrowed and undermined so substantially as the Supreme Court held in Lucasfilm, one has to be very careful about what can be gleaned from it, which remains good law. And in my submission, one is best to take that from Lucasfilm. But there is one part which has been repeatedly cited in the subsequent case law. This was a case, as the court may well know, in which a Portuguese company sought to sue a British company owned by Cecil Rhodes for having invaded and taken a large and valuable area of land in Mozambique. And the incidentally test, so the first of the two conditions upon which I rely, emerges from page 626 of the report, which is page 36 of the bundle. Lord Herschel, at the top of page 36 of the bundle, says it's quite true that in the exercise of the undoubted jurisdiction of the court, it may become necessary incidentally to investigate and determine the title to foreign lands, but it does not seem to me to follow that because such a question may incidentally arise and fall to be adjudicated upon, the courts possess, or that it is expedient they should exercise jurisdiction to try an action founded on a disputed claim of title to foreign lands. So that's, again, the first of my two conditions, the incidental test. Moving forward in the chronology of cases, we can go to Patney and Ali, which is in tab 7. This was a case in which the Kenyan courts had reached a conclusion that an agreement governed by Kenyan law required the respondents to transfer shares in an Isle of Man company to the appellant. And the Isle of Man courts, when asked to enforce that judgment, had concluded that it was a decision in rem, which the Kenyan courts had no jurisdiction to reach, and the Privy Council disagreed. And in the course of considering whether this was a decision in rem or in personam, Lord Mance for the Privy Council considered the contractual exception to Mozambique. So this is at paragraph 25 at page 133. An order, so paragraph 25, page 133, an order purporting actually to transfer or dispose of property is, however, to be distinguished from a judgment determining the contractual rights of the parties to property. Courts frequently adjudicate on the rights to property and otherwise of parties before them, arising from contractual transactions relating to movables or intangibles situate in other states. In doing so, common law courts apply the governing law of the relevant contract and the lex situs of the relevant movable or intangible to the contractual and proprietary aspects of the transaction. So there's then a reference to Dicey. Then Lord Mance observes, immovables fall into a different and special category in private international law, citing Mozambique, Dicey and Cheshire. Even so, it has long been accepted in England that an English court may, as between parties before it, give an in personam judgment to enforce contractual or equitable rights in respect of immovable property situate in a foreign country. Citing Dicey, the authorities go back to at least the first half of the 18th century, and then there's citation and discussion of Penn and Lord Baltimore. Such an order, and I didn't in fact show the court this part of Penn and Baltimore, but the sentence beginning such an order, Lord Hardwicke Elsey said, referring to a previous order made with reference to the land of Lord Anglesey in Ireland, could not be enforced in rem, but could be enforced by process of contempt in personam and sequestration, which is the proper jurisdiction of this court. Now I pause here to note, of course, that patents are not immovables, so the Mozambique rule is being applied by analogy to patents in any event. But this is a clear endorsement of the existence of the contractual exception under which matters otherwise outside the court's jurisdiction can be decided, if necessary, to enforce an agreement between the parties. We then move to Lucasfilm, which is in the next tab, tab 8, at page 139 of the bundle. This was the well-known case about the Stormtrooper helmet from the Star Wars films, and a copyright infringement claim was brought in England by Lucasfilm, which pleaded infringement not just of UK copyright, but also of US copyright. And in the Supreme Court, there were two sets of issues. The first set of issues, which doesn't concern us, was about whether the helmet qualified as a sculpture for the purposes of copyright law. The second question was whether the US copyright claim was justiciable or not. And issue 2 starts at page 229 at paragraph 50. That's 229 of the report, 160 of the bundle. You've been taken to some of this today, and you've seen paragraph 50. Paragraph 51, the Court of Appeal decided that the claim for breach of the United States copyright was non-justiciable. It held that the rule in Mozambique, etc., was an example of a general principle which applied not only to foreign land, but also to claims for infringement of foreign intellectual property rights, including copyright, irrespective of whether issues of title or validity were involved. And that is the decision that the Supreme Court overruled. Mozambique is discussed in paragraph 54 onwards, and it's notable that at the very outset, even when formulating what the rule decided in Mozambique was, the Supreme Court said immediately at the top of the next page, the rule has for long been subject to an exception where there is a contract or an equity between the parties which the courts of equity will enforce. So that's again the contractual exception. A court can determine title or right to possession of foreign land if it's doing so to enforce the terms of a contract. Now the court engaged in, as it described it at paragraph 53, some legal archaeology. And that occupies essentially paragraph 60 to 100. And I'm going to come back to those in the context of the Act of State point, because they're a consideration of Potter and Broken Hill, as you can see from paragraph 60, and to what extent that decision had been undermined. For present purposes on Mozambique, all I need to do, first of all, is to show you another point on the contractual exception, which is at page 170 of the bundle, page 239 of the report. In relation to the contractual exception, in paragraph 96, Lords Walker and Collins discussed the Griggs case, 7 lines up from the bottom. In Griggs, Mr. Justice Vinelock's decision was criticised by Mr. Peter Prescott QC, sitting as a Deputy High Court Judge, who distinguished it by applying the exception to the Mozambique rule, whereby jurisdiction could be exercised if there were a contract or an equity between the parties. And then there's description of the effect of the decision, and one sees at the end of that paragraph it would not be a breach of comity to adjudicate in personam on rights to foreign intellectual property right arising out of a contract. The formulation, the ultimate formulation of the rule comes in paragraph 105 at page 173. We have come to the firm conclusion that in the case of a claim for infringement of copyright of the present kind, the claim is one over which the English court has jurisdiction, provided that there is a basis for in personam jurisdiction over the defendant, or to put it differently, the claim is justiciable. It is clear that much of the underpinning of the Mozambique rule and the decision in Potter has been eroded. All that is left of the Mozambique rule is that there is no jurisdiction in proceedings for infringement of rights in foreign land where the proceedings are principally concerned with a question of the title or the right to possession of that property. So one sees again the principally concerned with test, the first of my 2 conditions. In paragraph 106, in the 6th line, the court said it's possible to see how the rationale of the Mozambique rule can be applied to patents, at any rate where questions of validity are involved. For example, the claims might touch on the validity of patents in sensitive areas, such as armaments. So the Supreme Court suggests that it may not even be all cases of patent invalidity that fall in principle within the rationale of Mozambique, only those relating to sensitive areas. But even if one assumes that all validity issues are within the rule, it is quite clear from the Supreme Court's discussion of the rule that the principally concerned with test would have to be met. That's paragraph 105, that's what the rule is. And that the contractual exception would be available. That's paragraphs 54 and 96 that I showed you. So the 2 elements of the rule on which I rely are again demonstrated. One sees those 2 elements in operation in the next case, Hamid and Stevens, which is in the next tab 9 at bundle page 176. This was an action by a British citizen against an Egyptian national habitually resident in England. It was a claim for money had and received, and the money was the purchase price for a flat in Egypt. And what had happened is that Mr. Stevens had transferred the money to Mr. Hamid, and Mr. Stevens' case was that the transaction had never completed and he hadn't become the owner of the property in Egypt. And Mr. Hamid said that couldn't be tried. It was barred by the Mozambique rule because it turned on the ownership of land in Egypt. The current formulation of the Mozambique rule was set out by the court at bundle page 183, paragraph 11, in the judgment of Lord Justice Lloyd Jones, as he then was for the court, approving the formulation of Dicey and Morris. The court has no jurisdiction to entertain proceedings for the determination of the title to or the right to possession of immovable property situated outside England, except where the claim is based on a contract or equity between the parties. So one sees again the contractual exception. The principally concerned with point we can see in operation at paragraph, well, there's discussion, as you can see, of Lucasfilm and the such like, but I can pick it up at paragraph 14. It has long been established that before the Mozambique rule can apply, the proceedings must raise directly the issue of title to foreign land. And there's then the reference from Mozambique and the passage from Saint-Pierre that my learned friend showed you earlier. So the distinction that's being drawn again is between proceedings which raise directly or are principally concerned with foreign land on the one hand, and on the other hand, issues that have to be decided collaterally in a case which is founded on personal obligations.
Is this where the word directly is first used? In 14? I haven't seen. I didn't see it.
I think that's probably right.
It wasn't used in
the principally, to explain where principally concerned comes from. I should perhaps.
I don't want to take you off your course.
No, it's potentially important because, as the argument this morning demonstrated, the precise way in which one formulates the terms of the rule in the first place can end up driving quite a lot of the conclusion. The way I put it is principally concerned with, because that's the way it's expressed at paragraph 105 of Lucasfilm, and that is drawn from Section 30 of the Civil Jurisdiction and Judgments Act 1982, which was passed in order to reverse a decision of the House of Lords in a case called Hesperides. And it's all in the decision in Lucasfilm. But it was, in paragraph 105 of Lucasfilm, it was adopted as the formulation of what the rule was. It was, as they put it, that was all that was left. And insofar as the court is using a slightly different expression here, it is, in a sense, it's paraphrase of the effect of the principally concerned expression. And one can see that in operation, that element of the test. In rejecting Mr. Hamid's submission, one sees at paragraph 17 over the page, at page 185. If Mr. Hamid does plead by way of defence a case that there was completion under the contract, the court may well have to decide as an issue of contractual performance whether that took place, so whether the Egyptian property transaction is completed or not. However, to my mind, that is not sufficient to bring the present proceedings within the exclusionary rule. First, these are not proceedings for the determination of the title to or the right of possession of land situated outside England, in the sense that that is the object of the proceedings. So that's another paraphrase of principally concerned with, say, is it the object of the proceedings? Secondly, any question of where title in the property was vested at any particular time would be purely incidental in these proceedings, which are, and then Lord Justice Lloyd Jones uses the language of Lucasfilm, principally concerned with questions of contractual performance and rights arising from alleged non-performance. That's principally concerned with. And then he observes, thirdly, that it was common ground the title was now vested in a subsequent purchase. As a result, there is no question of a judgment in the present proceedings having any effect on title to land situated abroad. Any remedy which may be awarded to Mr. Stevens would be a personal remedy for the recovery of monies from Mr. Hamid, and there is no basis for the suggestion by Mr. Pennock on behalf of Mr. Hamid that any determination by the English courts of whether the original transaction was completed or not may affect the validity of subsequent transactions in Egypt and the validity of the ownership of the current owner. So the court was saying, we will only be deciding this between the parties for the purposes of settling the claim for money hadn't received. We're not purporting to affect the ownership of the land in Egypt, but we have to decide this question in order to resolve the personal claim that's been made in these proceedings and over which the court has jurisdiction. So the court finds it's not within the scope of what remains of the exclusionary rule of common law. The court then comes to the second element of the Mozambique rule on which I rely, the contractual exception. Paragraph 19. In any event, I consider that this case clearly falls within a long-established exception to the Mozambique rule. And then there's citation of Patney against Ali and the passage that I've already shown you. This exception has its origin in the practice of the Court of Chancery, etc. There's reference to Penn and Baltimore, Deschamps against Miller, the passage that you've been shown. And the reasons in this case are paragraphs 21 onwards, at bundle page 187. The present dispute seems to me to fall within this exception. If the English courts may order specific performance of personal obligations to transfer land situated abroad, I can see no reason why they should not exercise jurisdiction over claiming restitution for the repayment of a contractual payment where the consideration is said to have failed. Indeed, the latter is a stronger case because the ruling will have no effect, even indirectly, on the ownership of or the rights to possess foreign land. Paragraph 24 is also important, given one of the answers that my learned friend gave you this morning. As you will see from paragraph 24, one of the submissions made on behalf of Mr. Hamid was that the contractual exception could not be available because the rights and duties in personam were governed by a foreign law rather than English law. It was submitted that the exception to the Mozambique rule does not apply here because, he submits, the rights and duties in personam of Mr. Stevens and Mr. Hamid are governed by the law of Egypt. Assuming for present purposes that this may be correct, it does not seem to me that this should constitute any bar to the exercise of jurisdiction by the English courts over these two defendants who are amenable to its jurisdiction. So the court held that what mattered was that the parties were within the jurisdiction of the court, which was well able to apply Egyptian law to the extent necessary. And note, there is no suggestion whatsoever that one needs an exclusive jurisdiction clause in favour of the English courts. Indeed, this was a case where the claim was for money hadn't received. So the court in Hamid both identified and applied the two elements of the Mozambique rule upon which I rely and which are summarised in paragraph 43 of our skeleton argument. One can then move to Chugai, which is in Authorities Bundle 2 at tab 15. Which is bundle page 642. And one can see what the facts of that case were from the first paragraph of the head note at page 642. There was a license under a portfolio of patents relating to an immunosuppressive drug. The claimant sought inter alia a declaration that he was not obliged to continue to pay royalties under the license in respect of its tocilizumab product. The defendants alleged that although framed as a claim for a declaration relating to a contract, a part of the proceedings, in substance, concerned not only the scope but also the validity of the US patent. Accordingly, a consideration of the claim would infringe the territorial limits, and then there was reliance on Mozambique, an active state. The only patent, as you can see from paragraph 2 of the judgment, the only patent still in force at the time of the judgment was a US patent. So it wasn't like this case where we have 11 pleaded patents under 6 different bodies of national law. The only patent in issue was a US patent. And the argument that was advanced, one can see at paragraph 7, that the challenge to justiciability was, as I noted at the outset of my submissions on this topic, limited to specified paragraphs of the statement of case. And it was those paragraphs which UCB sought to strike out. And they related, it was 2H and 25 to 35. And you can see how the arguments flowed over the page at 646. Paragraph 12, the dispute between the parties identified by these paragraphs concerns the scope of the relevant claims of the 771 patent, in particular the correct interpretation of the term non-human donor. So there's a dispute about interpretation. 13, however, Chugai has 2 additional arguments which it alleges should lead to the same conclusion concerning the scope of the claims of the 771 patent. And the relevant one for our purposes was the second additional argument, which is summarised at 15. And it was a construction argument to the effect that claims should be so construed, if possible, as to sustain their validity, quoting from paragraph 2H of the statement of case at the bottom of that page. And you can see at 16, Chugai had explained how in its submission the United States approach to ambiguous claims supported its construction, and 17, it explained precise and pleaded why they said it would be invalid on UCB's construction. So that was what was said to be objectionable. There was no suggestion that that meant that the entire contractual claim was non-justiciable. I pause to note. The discussion of the Mozambique rule begins at paragraph 48 at page 654. Mr. Justice Henry Carr started, as is understandable, with the decision in Lucasfilm at paragraph 48. But for the purposes of picking up the 2 elements of my test, I obviously rely on paragraph 52, which cites para 105 of Lucasfilm. That's the principally concerned with test again. And then at 55, Mr. Justice Henry Carr identifies the second element of the rule on which I rely. There are certain long-standing exceptions to the rule in Mozambique. I have already mentioned the contractual exception, which was referred to in the Griggs case and the Lucasfilm case. The exception was discussed by the Court of Appeal in Stevens, and then there's reference to the parts of Stevens that I have shown you. At 56, Mr. Justice Henry Carr comes back to the first element of the test. He refers to Lucasfilm, and that it can only apply to proceedings which are principally concerned with a question of the title to or the right to possession of foreign land. A similar exception was referred to in the judgment of Lord Justice Lloyd Jones, etc. And then there's reference to Stevens. So the court identifies the 2 elements of the test on which I rely and then applies them at paragraphs 57 to 60, page 657. At 57, his first reason is there's no contention that 771 is invalid. The second, paragraph 58, applies the principally concerned with test. There is no direct challenge to validity by Chugai, and insofar as the issue arises at all, it will only do so incidentally in support of Chugai's case that its construction should be accepted, this dispute is clearly not principally concerned with the question of validity. Thirdly, Chugai's case is correctly characterised as a contractual claim for a declaration that no royalties are due under the licence, because Chugai's product is not one that falls within the scope of a claim of the 771 patent, irrespective of its validity. So this decision fully supports the two elements of the rule on which I rely. The following paragraphs I'll come back to when we come to Act of State, but I do need to pick up paragraph 70 onwards at page 660 under the heading Direct Challenges to Validity of Foreign Patents. Now, the first point to note is what Mr. Justice Henry Carr considered himself to be doing in this passage, and that emerges from paragraph 70. In case this application goes further, it may be helpful for me to indicate the course I would have taken if I had considered that Chugai was seeking to invalidate the 771 patent in the English court. Now, of course, there's no suggestion that anybody is trying to invalidate any of the foreign patents in these English proceedings. And at paragraph 71, he then goes on, that leaves the wider question of whether in the absence of agreement, direct challenges to the validity of foreign patents, which are outside the scope of Article 22.4, are justiciable here. So he's assuming that it's a direct challenge. And one can see what he means by that from paragraph 73. In my view, there are powerful arguments that such direct challenges, where validity is the principal issue. So again, principally concerned with principal issue. So this whole discussion is assuming that the case, the hypothetical case that Mr. Justice Henry Carr is considering, is principally concerned with validity. And of course, there is no discussion here of the contractual exception, which on his own reasoning would remain available, and there's no cause for Mr. Justice Henry Carr to consider that, because what he's asking here is a question about direct challenges to validity, not challenges that arise in the context of a dispute about personal obligations under a contract. Now, my learned friend finally showed you Briggs, and Briggs also refers to the contractual exception. That's tab 24 of this bundle, page 866. Just after the passage that my learned friend showed you, at the bottom of the page, we have on the footing that the Mozambique rule still applies to disputes concerning the validity of a foreign patent, which Unwired described as undisputed. I pause there to note that if the rule applies, then it is a rule which only applies to cases principally concerned with. But the commentary goes on. It is also modified by the equitable rule in Penn and Baltimore. It means that the court will have jurisdiction to enforce a contract or other equity between the parties which relates to the foreign patent, such as a contractual license to use it. So in my submission, the authorities are very clear that in order to engage the Mozambique rule, the two conditions we identify at paragraph 43 of our skeleton must be satisfied. The proceedings must be principally concerned with the validity of foreign patents, and secondly, the claim must not be based on the enforcement of a personal, contractual, or equitable obligation between the parties. I come then to apply those principles to this case, and we submit quite simply that neither of those conditions was satisfied in this case. The first condition was the basis upon which the High Court resolved the case, and therefore it didn't need to resolve the second, the question of the contractual exception. Now, my learned friend said this morning that the contractual exception was not in issue before the High Court. That is not right. It certainly was in issue. Otsuka's skeleton before the High Court is in the supplemental bundle, and one can see the point being expressly referred to. It's Supplemental Bundle, tab 12, bundle page 187, discussing the principles. Otsuka, at paragraph 50, bundle page 187, said the rule does not extend, however, to cases in which a personal obligation arises between the parties, such as a contract, even if the subject matter of the contract relates to foreign land. And the submissions that were made in reliance on that, at 55 over the page, you can see the issue is therefore not only incidental in the sense that it arises as part of a proposed defence to an in personam contractual claim, it is also conditional, and then far more explicitly at paragraph 57.1, the issue raised by GW Pharma is raised as an intended defence to a contractual claim for royalties due under the agreement, and is therefore within the well-established contractual exception to Mozambique outlined in paragraphs 50 and 52.1 above. And it was certainly argued at the hearing. So there's no question of it not having been pursued in the High Court. It wasn't necessary for the judge to resolve it because of his conclusion on the first issue. And for that reason, I'm pursuing it by way of a respondent's notice, but it was certainly an issue. Let me turn then to deal with each of the conditions. The first condition is the claim principally concerned with foreign patent validity? Now, before I can make my submissions on that, one does need to go into the background a little and into the somewhat extraordinary way in which the validity issues are said to arise in this case at all. The agreement itself requires no consideration of foreign patent invalidity to enforce, and we can see this from the agreement. It's confidential bundle tab 1. At page 4 onwards. The royalty obligation on which we rely is at clause 9.1, which can be found at bundle page 53. With respect to any GW Pharma product, that's defined, permitted under the...
I remember what Ms. Byrne said earlier about this.
Oh, indeed. My apologies. Let me explain.
And it's live streamed. That's just...
Indeed. I should have explained this before diving in. The position is that a lot of this agreement is not confidential at all, and was in fact filed with the Securities and Exchange Commission in the USA. The parties have liaised as to what was not made public by the SEC and have produced a marked up version which I'm sure can be supplied to the court. But for present purposes, certainly with the clauses I'm going to take you to, the only thing that matters is the royalty rate. So I shan't read that out, but the other clauses I'm reading, as I understand it, there's no objection at all. They're just the mechanics of the agreement, and I'm sure my learned friend can tell me if that's wrong. But
she's certainly nodding.
Yes, the thing that I shouldn't read out and have therefore actually just scrubbed out in my own copy is the royalty, which appears in the third line. But that's it. So with respect to any GW Pharma product permitted under the agreement to be made, used, sold or imported under a license to collaboration IP and covered by a valid claim thereof, GW Pharma shall pay to Otsuka a royalty on net sales of such GW Pharma product by GW Pharma, its affiliates and their sub-licensees until the expiration of the last valid claim on a country-by-country basis. So that's the royalty obligation. So the first question is Epidiolex a GW Pharma product? That's defined in clause 7.4, which is at bundle page 48. As you can see, what this clause related to was GW Pharma's rights inside the research field, but after the collaboration had ended. And in broad terms, what 7.4 and 9.1 do is state that GW Pharma is perfectly allowed to do things within the scope of the collaboration IP after the expiration of the collaboration, but subject to the payment of the royalty in 9.1, so long as the requirements are satisfied. And you can see in the fourth line at the bottom of 48, GW Pharma shall have an exclusive worldwide sub-licensable royalty-bearing license to use collaboration IP, so those are the jointly owned patents developed during the collaboration, other than that relating to any selected drug candidate, or product subject to a license agreement or being developed pursuant to the provisions of 14.1.2, for any purpose whatsoever inside the research field, including for the research, development and commercialization of product candidates and products inside the research field. Any product developed by GW Pharma or its licensees, in this way covered by collaboration IP, shall be a GW Pharma product. So that's what a GW Pharma product is. And under both 9.1 and 7.4, the product has to be covered, capital C, by a valid claim. Covered we can find at 1.1.19, which is at page 10 of the bundle. Cover, capital C, shall mean with respect to a patent right that the making, using or other commercialization of a given product in a commercialized form would infringe a valid claim of such patent rights in the country where such activity occurs in the absence of a license under such patent right. So again, very common provisions in patent licenses. The royalty depends on whether the product would infringe but for the license. And then valid claim, capital V, capital C, one sees clause 1.1.98, which is at page 26. Bundle page 26. Valid claim shall mean, and as regards patents rather than applications, a claim of an issued and unexpired patent included within patent rights which has not been held, permanently revoked, unenforceable or invalid by a decision of a court or other governmental agency of competent jurisdiction, unappealable or unappealed within the time allowed for appeal, and which has not been admitted to be invalid or unenforceable through reissue or disclaimer or otherwise. So the parties have decided and have agreed what a valid claim is, and they've agreed that unless a claim has been revoked or held invalid by a court of competent jurisdiction or governmental agency, then royalties are owed.
So the word valid there is not being used in the same sense as saying this patent is invalid.
Quite so. There's a specific contractual definition.
Basically, it means in force.
Essentially.
Yes.
And that is exactly the way in which the claim is then pleaded.
What it's worth, Mr. Segan, just for the benefit of you and everybody else, that's actually quite a common way of drafting patents.
Yes, indeed, Michael. Yes, and one can see. Perhaps should have picked it up, but it's almost exactly the same way that the license was drafted in Chugai. I think it's around about the mid-20s of the paragraphs of Chugai where they consider the provisions, and they were the same provisions in that case. They were also the provisions in the Celtec case, which is cited in Chugai. So this is quite a common structure. And so what needs to be asserted to give rise to the royalty is that there is a valid claim which would be infringed but for the license, and there's a valid claim as defined. And that's exactly the way that the claim is pleaded. One can see Core Bundle tab 10. Now I've taken you through the agreement the court will see from bundle page 126 that the declarations that my client is asking for are all expressed in terms of the obligations that we've just been looking at. So 1 is falling within the scope, 2 is a declaration that but for the license the relevant patents and each of them have been, are and will be infringed. So that's covered with a capital C, which is slightly bootstrapped because, belt and braces, because 3 is a declaration that Epidiolex is covered, capital C, by a valid claim, capital V, capital C, of the relevant patents. And then 4, which is the nub of the thing, that royalties are therefore payable under 9.1 and we see on account. That's how the claim is pleaded by reference to the agreement. The product in issue in this case, as we know, is Epidiolex. It's used to treat seizures associated with a number of conditions, including 2 types of epilepsy.
Is the word valid used a different way in the draft counterclaim in the letter we were shown from GW?
I think it is, because what they say, as I understand it, the Lear defence, as I understand it, it said that can override the provisions of the agreement. So my learned friends say that as a matter of US public policy, if it's right that the patents are invalid, then they are entitled to a defence even in relation to royalties before the point at which a competent court or governmental authority revokes the patents in question. Now, whether that is right or wrong is to be resolved between the US lawyers in due course. The question for present purposes is that a debate which the English court is even entitled to entertain? And for all the reasons I'm advancing in my submission, it certainly is. Because the 2 conditions of the Mozambique rule are not met by my learned friends, by these proceedings, which is what one has to attest by reference to. And we say Epidiolex is the result of the collaboration between the parties, which occurred between 2007 and 2013. And whether it is or not, it seems is going to be the key factual question at this trial. And we say it's pretty clear. If one goes back to the agreement, which is confidential bundle tab 1, page, and if we go to page 103, you can see the research plan that the parties actually agreed on. So this is confidential bundle tab 1, bundle page 103. First point to note is the locations in the under research sites, which, as you can see, are very largely in the UK. And then at the bottom we have the epilepsy element of the collaboration in the right hand column. And you can see the names of the 2 scientists at the University of Reading who were going to be involved in this. Research, I should say, funded by my client. And one can see how this turned out, certainly in the view of the University of Reading, in the supplemental bundle at tab 10, page 137. This is a press release from the University of Reading, November 2020. Second paragraph, at bundle page 137. In September 2019, after many years of research at the
Are you in the
supplemental bundle,
sorry.
tab 10, page 137. In September 2019, after many years of research at the University of Reading, led by Professors Claire Williams, Gary Stevens and Ben Wally. Well, you'll recognise two of those names from the research plan I've just shown you. A new drug, Epidiolex, became the first cannabinoid-derived medicine to be approved in the EU for clinical use in epilepsy. And I won't read it all out, but as you can see under the heading 2 decades in the making, they explain the involvement of Mr. Wally and Mr. Stevens. Second paragraph, in 2007 they were approached along with Professor Gary Stevens by GW, a company specialising in plant-derived cannabinoid therapeutics, to test the use of cannabinoids in reducing seizures. There's then reference to my client. Following the success of these tests, GW and Otsuka awarded the team more than £1 million to conduct further research with a view to developing a drug. Otsuka was so impressed by the team's initial data that they sent 3 of their employees to Reading, who became embedded in the pharmacology group. By 2012, the Reading team had shown that CBD and another largely ignored natural compound found in cannabis both strongly suppressed seizures in several rats and mice treated to multiple symptoms, etc. So that's during the research collaboration, and you can see the University of Reading's view is that Epidiolex was the result of this research and collaboration. As we shall see in a bit, GW Pharma now say, as a key plank, as the key factual plank of their defence, that that's all wrong, and that in fact the product emerged independently of the research collaboration altogether. But coming back to the nature of the claim, our contention in these proceedings, quite simply, is that if we're right that the product falls within the scope of a valid claim in particular countries, then we're entitled to a royalty on sales there. And insofar as the issue of infringement is raised, it's raised because the parties' agreement requires any court or tribunal enforcing this agreement to consider it. Now, how have we then ended up in the Court of Appeal arguing about the Mozambique rule? Well, the answer lies in a long and somewhat tortuous history, which is covered in section 2 of our skeleton argument, which is Core Bundle 5, page 52 onwards. And one of the really striking points is how late in the day any suggestion by GW Pharma that the jointly owned patents were invalid actually arose. As you will see from paragraph 9 of our skeleton, GW Pharma initially accepted that it would have to pay royalties on Epidiolex. Now they say those statements are confidential, so they're blanked out in the version that's in the core bundle, but there's a confidential version of our skeleton at the back of the confidential bundle. The detail doesn't matter for present purposes. The statements were made to the effect that royalties would be paid. My client invested overall a very substantial amount of money in the collaboration. There was a joint research committee that met in the UK. The research was undertaken, as you've seen, in the UK, and the result was the jointly owned patents, amongst other things, all of the patents that we plead in the particular claim. Paragraphs 13 to 14 of our skeleton, those patents were then, the validity of 2 of those patents was then defended by GW Pharma before the US and European patent authorities, including the validity of US 920, which they now say is invalid, but also EP 637, but defended by GW Pharma at my client's expense, which was the arrangement under the agreement. And what is more, as we explain at paragraph 15, all of the relevant patents relied upon in this case were assigned by GW Pharma as security for a loan from a US bank in July 2021, and that was done notwithstanding the fact that those are the very same patents they now apparently wish to say are invalid. Now, why the change of position? Well, the answer is, of course, money. As we explain in paragraph 10 of the skeleton, from 2018 onwards, GW Pharma has obtained authorization for Epidiolex, and it's been marketing it increasingly broadly. We say it's covered by the patents. GW Pharma also thought it was covered by the patents in the past, and the resulting royalty obligation is considerable. The net sales in 2020 were over $500 million. And as we explain in paragraph 80.3 of our skeleton, the proportion of those sales accounted for by the USA has been declining over time as GW Pharma launches Epidiolex in more jurisdictions. The figure of 95% has been used. That is no longer accurate. That's an average in the past. As we point out in that paragraph and in the evidence, even in 2021 it was 92% for the USA, but even since we launched these proceedings, there have been further launches of the product in Norway, in Ireland, in Spain, I believe also either already or very soon in France. So the idea that this is just a dispute about the USA is simply incorrect as a matter of fact. My client has been trying to raise its royalty entitlement for a long, long time. It first raised it in May 2019, that's paragraph 16 of the skeleton, after more than 2 years of discussions, as we point out in paragraph 17, in June 2021. When it became clear that there was not going to be a resolution, my client commenced an arbitration, which under the terms of the agreement is to take place here in London. The arbitration pleadings are in the confidential bundle, tabs 7 and 8. And when GW Pharma filed its answer in the arbitration, rather than simply agreeing to resolve the matter in the arbitration, it argued that the claim raised by Otsuka was outside the arbitration clause because it related to patent scope, and so it had to be resolved in court. The answer did, however, address the substance at some length. This is confidential bundle tab 8, and I won't go through it all. This is, after all, an ongoing arbitration. It's 54 pages long, and it attempts to answer many of the points, the covered points, the in this way covered, etc. What you will not find anywhere in all 54 pages of this arbitration answer is any suggestion that the patents relied upon are invalid. There is a very oblique reference, perhaps, to the not patentably distinct point, but there is no suggestion that all the relevant patents are invalid. And to the contrary, as you will see, the suggestion, the contention was that the discussions to date had focused on scope and infringement. That's paragraph 6, 43 and 47 to 49. Now, the jurisdictional point was taken. It was said, well, you can't resolve part of your claim in this arbitration. You have to go in court. So my clients, and by the way, sometimes it's insinuated that a suggestion was made that we should sue in New York State Court. That's just not right. As Mr. Wexler explains at paragraphs 9 to 10 of his first statement, the suggestion was simply it needed to be resolved in court. And my client obviously did not want to spend further time debating procedural matters, and so issued a claim here, which is, after all, the defendant's home jurisdiction, where the collaboration took place and where all the product is manufactured. And one might have thought that at that point GW Pharma would have accepted that we should get on with resolving the matter on the merits, but the response has been yet further skirmishing and delay, because GW Pharma now indicated in its acknowledgement of service an intention to challenge English jurisdiction. And it was only at this point, for the purposes of the jurisdictional objection to the English courts, that the contentions about the alleged invalidity of the jointly owned patent suddenly emerged. And they did so incrementally, because in the first round evidence filed by GW Pharma, the point was limited to just the US 920 patent. That's one of the 11 pleaded patents. But then, as the rounds of evidence developed, it expanded to all of the pleaded patents. And we can see this in the draft defences letter, which is in the supplemental bundle at tab 15. So this was sent on the 1st of March. This was, I think, 2 days before we had to exchange skeletons in the High Court. And the letter, we've attempted to summarise the defences in paragraph 25 of our skeleton, but it's 3 or possibly 4. But the factual meat of the defence you can see at paragraph 5 onwards. Under the heading, Epidiolex was developed independently of the collaboration between Otsuka and GW. So the case that's being made, and it goes on all the way through to paragraph 24, the meat of the factual case is a suggestion that Epidiolex was developed independently of the research collaboration. They say, in effect, that press release I showed you from the Reading University was fundamentally wrong, and that Epidiolex essentially had nothing to do with the research collaboration. Paragraph 8, for instance, Epidiolex is a commercial product of which CBD is the active ingredient, but it did not result from the research collaboration. It was a result of work by GW carried out independently of the research collaboration. And one can see like contentions at paragraph 19 onwards. All the things that is said that the research collaboration did not do or was not focused on. Paragraph 20, it was by no means focused on cannabidiol or epilepsy or whatever, and one can read through. I'm not going to read it all out. And 24 is about the research that the parties conducted or sponsored under the collaboration. And the relevance of all of that is said to be, the punchline is the point that's made at 25C. They say that as a result of all of that, Epidiolex is not a GW Pharma product. Because on their case, to be one, it has to have emerged from the research between the parties, and they say on the facts that didn't happen. Now, although that is arranged in third place for perhaps forensic reasons, that logically is the first issue. It will certainly be the focus of the bulk of the evidence, as one can see just by looking at this document. The question quite simply is what happened or did not happen during the research collaboration between 2007 and 2013 here in the UK. Now there are then the further issues they raise in paragraph 25. A is that Epidiolex is not covered by any claim of the collaboration IP. And then they say, alternatively, were Epidiolex to be covered, that claim would be invalid. So it's conditional upon the failure of their case on scope, and logically also on the failure of their case on GW Pharma product. One can see that developed at page at the bottom of that page. The heading is, were Epidiolex to be covered by any of the relevant patents, that claim would be invalid. One can see the extension to all the patents in the case at paragraph 29. The claims under the other relevant patents, if construed to cover Epidiolex, would also suffer from similar deficiencies under the patent laws of their respective jurisdictions. And then you can see in 31 the obviousness point is developed. And 30 explains that it can arise, so it's said, under the Lear doctrine. So, despite not having said this in the arbitration, despite jointly owning these patents, despite having defended their validity before the patent authorities, and despite currently using those very patents as security for a finance facility from a bank, GW say that if all else fails, then they want to argue that the patents are all invalid, all 11 of them, under their governing laws. And that's explicitly a last-ditch defence if all else fails. And one can see that from the way in which the draft defence's letter is put. And for good measure, it's pleaded in the same way in the defence. Core tab 12. Paragraph 79 and 82. And these are the paragraphs we looked at earlier, page 139. Page 139, middle of the page, under the heading Invalidity of the claims relied on, Patent Family 1. It is said, if, contrary to the foregoing, any of the claims of patents of Patent Family 1 is construed such that, etc., the defendants will contend that the said claim is invalid and therefore A is not a valid claim, and or B, under the Lear doctrine, no royalty is due. And then 82 is the obviousness point, further or in the alternative. So it is said, well, as a last ditch, all of the patents are invalid. And it is said that simply by saying that, simply by pleading that last ditch defence, the whole claim becomes non-justiciable and must simply end. And that is an untenable submission by reference to the two elements of the Mozambique rule that I've already identified. The first point is that the claim is not principally concerned with foreign patent validity. And we've set out 5 reasons in that regard in paragraphs 56 onwards of our skeleton argument, and I'm going to develop them orally. That's core tab 5, page 65. The first point we make is that, as will have become clear to the court, I hope from my review, the issue of validity may never arise in these proceedings at all. And there are a whole series of reasons why that's the case. The first that we mentioned is that GW Pharma is, on our case, is stopped from disputing the validity of its own patents in the quite extraordinary circumstances of this case. That's a point that the judge envisaged expressly in paragraph 76 of his judgment, and it's pleaded at paragraph 15 of our reply. If successful in that plea, then the issue will simply never arise. Further, GW Pharma's own case is that we won't get to that point because it will win on the issue of whether the product is a GW Pharma product. That's the whole factual debate about what happened in the research collaboration, or else on its construction of the claims. Now, we of course say those points will be rejected, but this just goes to show how far we are away from a claim which is principally concerned with validity. And what is more, if all of those points go away, as the judge pointed out, there is always the possibility to exercise case management powers if validity does come up in a way that seems to be objectionable. None of this establishes that the claim is principally concerned with validity. The second point we make on this in our skeleton is that insofar as validity points do arise, they're not the principal concern of the claim, they arise incidentally to the resolution of the contractual issues which are the focus of the proceedings. They arise only for the purpose of establishing in personam and between the parties whether GW Pharma owes Otsuka royalties under the agreement. GW Pharma would not be asking the court to invalidate any of the foreign patents, nor could it do so. Nor indeed, as it happens, could the New York State Court. It's actually common ground that New York State Court couldn't invalidate even a US patent, let alone anybody else's patent, and that's Wexler 1, paragraph 28, Diamond 2, paragraphs 48 and 51, and Wexler 2, paragraphs 5 to 7. Now, in an attempt to meet this point, in paragraph 25.3 of my learned friend's skeleton, and it was repeated this morning, the suggestion was made that an English judgment resolving the Lear defence could have preclusive effect in a federal court in the United States. And so it was said, in fact, this could preclude us in the States. You've not been shown any authority for that proposition at all, with respect. There were two things that you were shown. The first was a case called Blonder Tongue, which wasn't cited below, which it's authorities 2, tab 18. You were taken to it this morning. And as is perfectly clear even from the head note, the decision deals only with the preclusive effect of an invalidity decision by a federal court in the USA. There is no discussion whatsoever even of US state court decisions, let alone decisions of a foreign court. And even in respect of federal decisions, the rule is not absolute. If one looks at the left-hand column towards the bottom, in summarising the decision, the Supreme Court, Mr. Justice White, held that in patent infringement suit, patentee is stopped to assert validity of patent that had been declared invalid in prior suit in federal court against a different defendant. And what this was all concerned with was the rule in a case called Triplett, which you can see at page 743 of the bundle. And essentially, the course that US law had taken up to that date was that if a patentee asserted a patent against one defendant in federal court, and it was adjudicated invalid, that did not create an issue preclusion in a subsequent case. So you could sue a different defendant, even though the federal court had said your patent was invalid, and all the issues would be up for grabs again. And the Supreme Court overruled that and said, well, frankly, it obviously doesn't make a great deal of sense. And they overruled the rule and said it could create an issue preclusion, but even then the rule was not absolute. But what you will find nowhere in this decision is any discussion of state courts in the USA. Still less does it say anything about an alleged issue preclusion arising from a foreign decision in which the point arises only as a collateral incident of a contractual case. The other source relied upon by my learned friend was an article from the University of Pennsylvania Law Review, which we see at tab 23 of Authorities Volume 2. Now this was, as you will see from the footnotes on bundle page 831, written by Mr. DeSalvo at a time when he was a doctoral candidate. He is now, so far as I can establish, an associate at Kirkland and Ellis. And I mean, no discourtesy whatsoever when I say that, therefore, describing this as a commentary, as my learned friend did, is, in my submission, rather over-egging things. This is an article in the University of Pennsylvania Law Review. It is proposing a new framework for US federal law. And one can see this throughout the article. In particular, if you go to page 834, the article describes what each part does. Part 2 is where he deals with the historical treatment, but part 3, which is where the bits that my learned friend relies on come from, in part 3 I argue that patent invalidity should not be treated as a single issue. As a result, I propose a new framework for courts to use when disposing of cases involving patent invalidity contentions. And you can see that from the start to part 3 at page 843, that you have the title making the case for a new preclusion framework in patent law. And indeed at 852, under the heading "The Search for a Better Procedural Tool," we have the court should move away from applying issue preclusion outside of the paradigmatic case, etc., etc. So this is proposing a new framework. But perhaps more importantly, again, it's dealing only with the preclusive effect of a decision of a federal court in the US. So if we go back to page 834 that we were looking at a moment ago, under the heading "Defining Issue Preclusion in Federal Court," line 3, because patent issues are litigated exclusively in federal courts, a brief review of the requirements for issue preclusion in federal courts is provided below. So, again, this article says nothing about preclusive effects of state court decisions, but much more importantly, it says nothing about alleged preclusive effect of a foreign decision. So the suggestion that an English decision on this issue, for the purpose of working out whether royalties are owed, will bind the US Patent Office or the federal courts has no support in the materials identified. Now, a further point which was made was to say, well, your claim is principally concerned because it's founded upon patents, and it can only have any life if those patents are valid. Well, that's true, but only in the sense that the parties' own agreement, the bargain that they actually struck, provided that royalties were payable if there was infringement of a valid claim. Capital V, capital C, as defined. Now, if that were sufficient to engage the Mozambique rule, then no claim under a license agreement relating to foreign patents could ever be brought, because they're all, by definition, founded upon validity, however one's defined it, as in this case it's actually defined in the agreement. And that cannot possibly be the right interpretation of the Mozambique rule. Then the third point we make in the skeleton is that the contrary conclusion would be a remarkable one, because it would entail the conclusion that a contractual royalty claim of this nature could never be tried by a single court anywhere. The claim already concerns sales in the UK, Germany, Switzerland, Australia, Israel, and the USA, and therefore the law on claim construction in those jurisdictions. It's actually common ground that further jurisdictions will or may need to be added as further launches take place. In paragraph 37.1 of my learned friend's skeleton, they make that observation. And as I think I've said already, even since the claim has been commenced, there have been launches in Spain, Italy, Norway, and Ireland, with France imminent. And the position of my learned friend, were it correct, would mean that one needed national proceedings in every single one of those jurisdictions, and that no single court could consider the dispute, because their position is one of exclusive jurisdiction over validity. And one can see this from their evidence. This is in the supplemental bundle. We'll start with Trevelyan 2, which is supplemental tab 1, and at bundle page 7, paragraph 25. As Trevelyan said, however, as will be further explained by legal submissions, the validity of a national patent is within the exclusive jurisdiction of the courts of the state which granted the patent. Accordingly, whether the US 920 patent is invalid is not a matter justiciable by the courts of England and Wales. And then they say the US one can only be resolved in the USA. And then what that entails in practical terms on their case is explained in Trevelyan 3, which is at supplemental bundle tab 5. And at page 74 of the bundle, at paragraph 17, meeting a point made on behalf of Otsuka, that there's no reason why the English court should not have jurisdiction over the remainder of the claim that relates to the other patents at issue. GW Pharma say to date, Otsuka has provided no indication it's willing to divide up its claim, to carve out the US 920, and seek determination of matters relating to the UK, European, Australian, and Israeli patents by the English court. And it's not clear if that is what Otsuka intends to propose. Although the matter is for legal submissions, it is briefly noted that in the event that either party to the claim were to seek a declaration of invalidity regarding the other foreign patents at issue in the claim, GW's position is that the English court does not have jurisdiction to make such a declaration, and that the court of the relevant state would have to be called on in such regard. But they then say, to the extent that issues of the validity of foreign patents might arise incidentally to the determination of contractual questions in the claim, they say, well, New York is better. But there's inevitably a squeeze there, because either my learned friends are right that validity is only being determined incidentally. That's the case they make in 18.2, in which case the Mozambique rule could never be engaged. It's the first part of Mozambique. Or, if they're right that somehow it crosses the line, their case would have to be that it can only be determined in a multiplicity of different national courts. That's paragraph 18.1. And developing the Mozambique rule or any exclusionary rule in that way would, in my submission, be inconsistent with the recent policy of the English courts. And one can see from the Fran cases like Unwide and Bannett, which is in favour of a one-stop shop, if at all possible. It is the idea of proceedings in 6 or 9 or 11 different jurisdictions is an outcome to which this court should come only if unavoidably driven to it, in my submission, which is simply not the case here. Now, of course, if GW Pharma had wanted to obtain a binding in rem decision about invalidity from a foreign court, it could have commenced proceedings. If it really thought these patents were invalid, it could have commenced proceedings in the relevant foreign jurisdictions long ago, in the ordinary way, and could have then triggered the definition of valid claim in the agreement. But of course, they haven't done so. The fourth point we make in the skeleton is that the Mozambique point could not conceivably apply to the claim insofar as it rests on UK patents. 3 of the 11 are UK patents. And so it couldn't, on any view, bar consideration of the claim insofar as it rests on those patents. Indeed, the logic of the argument would be that this is the only court that can consider that. And finally, fifthly, we make the point that there's simply no reason to apply any alleged bar at this stage of proceedings. That's essentially a variant on the first point. So there's no... In the end, I submit the judge was absolutely right to find this claim is not principally concerned with patent validity, and that is the end of the road on Mozambique. There's no partial strikeout application or anything of that nature. The claim proceeds. The principal concern is the enforcement of the parties' obligations to each other. There is mention in my learned friend's skeleton of 2 first instance decisions. One, this is paragraph 24.3 to 24.4. One, Activis and Eli Lilly, and the other, Anand Kazai in Molycorp. But they are both decisions under the Brussels regulation. They make no reference to the Mozambique rule at all, and they decide nothing under it. They were also claims for infringement of a foreign patent or for a declaration of non-infringement of a foreign patent. They were not contractual royalty claims. So on the first condition, we say this claim is clearly not principally concerned with validity. Suppose I'm wrong in that, one then turns to the second condition and asks, well, is this claim founded on a contractual in personam obligation so as to fall within the exception? And the answer is yes, it is. It's self-evident from just looking at the claim as pleaded. I've shown you the various formulations in Patney and Ali, in Lucasfilm and in Hamid. Hamid approves the Dicey rule, which formulates the exception as being except where the claim is based on a contract between the parties. That's what this is. And not a single one of those decisions refers to the need for an exclusive jurisdiction clause or anything of that nature. It's true there have been cases in which that was influential. Chugai is an example. But none of the cases say you have to have an exclusive jurisdiction clause. Indeed, as Hamid makes clear, as you may recall, you can even have the exception engaged where the personal obligations are non-contractual and they may be governed by foreign law, in that case, Egyptian law. And there hasn't really been any coherent answer to that point in my submission. Taking the answers that were advanced earlier today in turn, first of all, it was said one needed an exclusive jurisdiction clause. Well, in my submission, there's just no support in the authorities for that as a requirement. And my learned friend then said it could only be available if the obligation was governed by English law. But that's contrary to paragraph 24 of Hamid. My learned friend then said that the claim would have to be purely contractual in order to come within the exception. But then that wouldn't be an exception at all if that were the case. The whole concept of an exception is that the claim is otherwise principally concerned with something that lies outside the jurisdiction of the court. And then finally, my learned friend said that any case where the patents are foreign would be objectionable. But if that were right, then one could never sue for royalties in the English court under a multi-jurisdictional patent license, whether validity was in issue or not. Every patent license is in that sense founded on a valid right. So there hasn't been any answer to the contractual exception. And for all of the reasons I have explained, therefore, neither of the two limbs of Mozambique on which we rely in paragraph 43 of our skeleton is satisfied. There is no bar to the consideration of my learned friend's proposed defences, and certainly not to consideration of the claim. That's grounds 1 and 2 on Mozambique. The other two I can take much more shortly. Ground 3, act of state. It's simply not a tenable submission on the authorities. Mr. Bala described it as ambitious, and I would respectfully agree with that and suggest to you that that is something of an understatement. When one needs to go through the cases in turn, I'll do it very quickly. One starts with Lucasfilm, it's Authorities 1, tab 8. And one sees at page 162 of the bundle a heading, Potter against Broken Hill. Now, the point to observe here is that this is in the course of the court's legal archaeology about the Mozambique rule, with which the court was explicitly and expressly concerned in this appeal. And the court says it's inevitable that any discussion of justiciability has to begin with Potter against Broken Hill. And there's a summary of what that Australian action decided. Then paragraph 61, second line, although the Mozambique rule is one of the elements in the conclusion of the High Court, an examination of the way in which the case was argued and of the reasoning of the High Court shows that it is a decision extending the acts of state doctrine to foreign patents. There are 4 strands to the conclusions reached by the full court. So, the act of state is not being considered purely out of academic interest. It is being considered because it is directly relevant to the line of reasoning being adopted by the court on the Mozambique rule. And the court referred to the 4 strands of the decision. The 4th strand is described by Lord Walker and Lord Collins at paragraph 65. As a result, there is a 4th and decisive strand in the decision, namely the act of state doctrine. The classic statement of the act of state doctrine was enunciated, and there's reference to the Supreme Court. 67 all three members of the High Court of Australia quoted and applied Underhill and Hernandez, and it is the Act of State doctrine rather than the Mozambique rule which is the essential foundation of the judgments in the High Court. And then 68, again pointing out the effect was especially to apply Act of State doctrine to actions for patent infringement. And what the Supreme Court then had to do was consider whether that was right and whether they agreed with this. And we see from 69 there have been major developments since the decisions in the Mozambique case and Potter against Broken Hill, which have to a significant extent undermined them, and to which it is now necessary to turn. 70, the questions to which these developments are relevant are these, and you can see the fifth one is, at the very end of that paragraph, whether the Act of State doctrine has any relevance to actions for infringement of intellectual property rights. So that's one of the questions that the court has to consider. And then 81 to 86, under the heading the Act of State doctrine at page 166, address that fifth question identified by the court. Now, I won't go through it all, but you can see at 85, it is said, in the Commonwealth, Potter appears to stand alone in using the Act of State doctrine as an impediment to actions for infringement of foreign intellectual property rights. And it's in that context, then, that the observation at 86 is made. And you've already seen it. The Supreme Court decided explicitly in the last 6 lines of paragraph 86, in England, the Foreign Act of State doctrine has not been applied to acts other than foreign legislation or governmental acts or officials, and it should not today be regarded as an impediment to an action for infringement of foreign intellectual property rights, even if validity of a grant is in issue. And that is part of the court's essential reasoning in the case. And one sees that, for instance, from 105 that I've already shown you at page 173. The reason that the court finds that the rule is much narrower than once was thought is you can see it is clear that much of the underpinning of the Mozambique rule and the decision in Potter has been
What about
erased.
the point made about the qualification in 105 and then Lord Manson at the end?
Yes, well, Lord Mance at the end, it's worth noting that it's Lord Mance at the end.
Yes, but Miss Byrne didn't just put it on the basis. No, it wasn't Miss Byrne. Miss Ballard. Sorry, forgive me. Put it on the basis of 101 too, which is Lord Walker and Lord Collins, I think.
Yes. Well, obviously, look, it's true that this case was about copyright. In that sense,
it's therefore over.
Well, it depends, because there are various formulations of what the ratio decidendi of a case actually is. I mean, one doesn't. In my submission, given the strength of authority I'm able to point to, it may be that in the end doesn't much matter. But this court, for instance, has, in a case called Kadim, has previously approved a formulation in Cross on precedent that it is any rule of law treated as essential to a judge's reasoning. But in a sense, whether it's ratio or extremely carefully considered reasoning of the Supreme Court directly relevant to the issue they were deciding doesn't much matter for my purposes in terms of the authority that it carries. The point that I'm making is that this was not a stray observation. Act of State was identified as the basis for Potter and Broken Hill. The ambit of Act of State and whether it was of any relevance to intellectual property rights was identified as one of the key questions in paragraph 70 subparagraph 5. And the decision in that regard was clear. Now, I mentioned about it being Lord Mance at paragraph 115. The relevance of that, of course, Lord Mance says, I'm not going to express a view on this for now. The relevance becomes clear when we go to Belhaj, which is in Authorities 2, tab 40. Because the passage that my learned friend showed you, at paragraph 73, subparagraph 4, is in the judgment of Lord Mance in the Supreme Court. At page 560 of the bundle, and whatever it is, 6 years have passed since Lucasfilm. Paragraph 73, Lord Mance says that the second type of foreign act of state is, assuming that it exists subject to significant limitations under English law, has become increasingly clear over recent years. The Court of Appeal was on any view correct in UCOS to identify the importance of these limitations thus. And then subparagraph 4 is acts of officials granting or registering intellectual property rights have been held to be outside any doctrine of foreign act of state.
Well, that's a summary of what Lucasfilm decided.
And
which includes what was said in 101, isn't it? And 115.
Well,
he doesn't extend what Lucasfilm decided. It doesn't purport to do that. It just purports to be a summary of what Lucasfilm decided.
Well, it's saying the Court of Appeals on any view correct to identify the importance of these limitations, and then appears, and there's no reservation to the effect, well, this might be wrong, and nor is there in the judgment of Lord Neuberger, which I don't think you were taken.
Sorry, Mr. Segan, I think the pen is just dropped. The point is this the point you're making? Forgive me for not picking it up. What Lord Mance is doing there in little 4 of 73 is specifically referring not to copyright, but to intellectual property rights created by the granting or registering of IP rights as being held to be outside the doctrine of active state, which is the very
That's
thing
certainly
he said he wasn't
what you said. It's exactly in Lucasfilm.
It's not just saying in 4 intellectual property rights, which could have included copyright.
Acts of officials.
He's actually taking.
So he is going further than was contrary to what I said.
As a matter of words, he's certainly going whether he meant what he said. I mean, we should assume he did, of course.
That isn't what Lucasfilm.
No, I in a sense,
right. I'm wrong. The law's
I
right.
see. Yes, it is differently expressed. But if Lord Mance had any remaining reservations about the principle that act of state should not apply in these circumstances, he certainly didn't express them here, and nor did Lord Neuberger, whose speech is actually the majority speech in this case, which is at paragraph 161, bundle page 590. And you can see the same point is repeated.
So give me the reference to that again.
Paragraph 161 at page 590. Lord Neuberger is the majority because he was agreed with by Lord Wilson, Baroness Hale and Lord Clark.
(161), did you say?
Yes. And there's reference again to paragraph 86 of Lucasfilm, which says very clearly that act of state doesn't apply in this situation, even if validity is in issue. And again, there's no suggestion that was wrong.
And again, here, Lord Neuberger is referring not just to intellectual property in general, but to a grant of a patent in particular.
And so refused to apply it to the grant of a patent. And the reason it specifically concerns the grant of a patent in Lucasfilm is because that's what Potter and Broken Hill was about. So the whole discussion of the role of active state is specifically concerned with patents in Lucasfilm because Potter, those are the facts of Potter. And as Lord Neuberger observes, refused to apply it to the grant of a patent. Now we then have Chugai, which came to the same view, paragraph 67 to 68 in Chugai, and we've already seen that. But then we have a unanimous decision of the Supreme Court earlier this year in the Venezuela case, which does the same thing. We have authorities to tab 16. this was a case in which active state was absolutely squarely at issue, just as it was in Belhadj. So one can see that there's a single judgment for the Supreme Court of Lord Lloyd Jones, so you can see that at page 668 of the bundle. And at paragraph 5.2 at bundle page 670, you can see that one of the issues for the court, one of the preliminary issues, was the active state issue. So it was one of the principal issues for the court. In dealing with that issue, which starts at page 697, the court, under the heading active state, engaged in a very detailed summary of the relevant principles. And one can see the start of 112, it's described as one of the most difficult and perplexing topics which may face the municipal judge in England. I don't think anybody at the bar will disagree with that. But so there's a whole discussion of the principles. 116 covers Rule 2. Paragraph 116 onwards is discussing Rule 2. So that's the rule that my learned friend relies on. That in itself is a long discussion. But one then sees at page 706, after the conclusion on Rule 2 at paragraph 135, we then have the heading Limitations and Exceptions. The various manifestations of foreign acts of state in English law are undoubtedly subject to limitations and exceptions. These were considered in detail in UCOS and may be summarised as follows. And subparagraph 7 is the active state doctrine should not be an impediment to an action for infringement of foreign intellectual property rights, even if validity of a grant is in issue, simply because the action calls into question the decision of a foreign official. So that is part of the essential and central reasoning of the court and its description of the relevant applicable principles in relation to active state. Indeed, they even mention, when summarising their reasons in paragraph 181, the exceptions. So, paragraph 181, bundle page 722, for these reasons I would allow the appeal in part and dismiss the cross appeal. 2a, there exists a rule of domestic law that, subject to important exceptions, courts in this jurisdiction will not adjudicate, etc. And respectfully, it's very difficult to see how what the Supreme Court said is not ratio decidendi. It's a case about active state, and the court was summarising in a unanimous decision the relevant principle. So here we have all four judges in Lucasfilm, who were in the majority in Lucasfilm, in a context in which the specific issue was patents because of Potter. And they come to a very clear conclusion in paragraph 86. We then have Belhadj, paragraph 161, Lord Neuberger endorsing that, and for good measure, Lord Mance at 73.4, who was the only judge who left the issue open in Lucasfilm. Chugai itself, and then Venezuela. And so, and whether one accepts that in fact Belhadj and Venezuela were ratio, and so the issue is formally simply not open to my learned friend, or simply treats them as, on any view, extremely powerful obiter dicta, the answer in my submission is clear. And the only reasons which are put forward for disagreeing with these conclusions are points which are actually considered in those cases. They're things like the decision in Bladd and Bamfield that was considered in the Belhadge case, as my learned friend showed you, or the Gennard report, which was considered explicitly in paragraph 85 of Lucasfilm before they decide the point against my learned friend's argument.
It's 86 in Lucasfilm, isn't it?
Yes.
Really. And what Lord Mance said in the second case wasn't what he said. Wasn't what he said at 115 in Lucasfilm, but was summarising the majority view.
Yes. And in terms which clearly related to patents. And in my submission, looking at Lucasfilm, it clearly was about patents because it was about Potter. And then one has Venezuela approving it. So it's the attempt to suggest that the issue is somehow open for decision neutrally, and the simple question is just what way should it be decided, is remarkable in my submission. There's an extremely powerful steer from 3 decisions of the Supreme Court on any view. And in my submission, both Belhadge and Venezuela are ratio, and so the point isn't open at all. But fundamentally, there's no argument that my learned friend has made against what was said in those cases, which was not, in fact, considered in them. As I say, the planks were things like Bladd and Gennard. That's ground 3. Ground 4 is forum non-conveniens. This was a case in which defendants...
How long is this going to take?
I'll be as quick as I possibly can.
Well, how long is that going to
probably
take?
about 10 minutes.
Yes.
We've got it in writing.
I think
you do have it in writing.
Yes, we do. And then Miss Byrne.
I have just 5 minutes of very brief reply and housekeeping, if I may.
Very well. Well, if you can be finished by 4:10, please.
Certainly, my lady. This is a case in which the proceedings have been served as of right on the defendants, so the burden lay on GW Pharma to satisfy the court there was another competent jurisdiction that was clearly or distinctly more appropriate. The relevant date for assessing that is the 4th of March 2022. That's in Briggs Authorities 2, tab 24, bundle page 870. The simple point is you assess this on the basis of the facts as they stood before the judge below. You can see at page 870 the material date for the purposes of the evidence and other facts and matters to which the court may be taken on the application for a stay is the date of the hearing of the application for a stay. And then over the page, at page 871, in the last sentence, if the circumstances change materially after the hearing, this fact may furnish grounds for an application by the defendant to lift the stay or justify a fresh application by the defendant for a stay, but it does not give ground for an appeal, for it does not establish there was anything wrong with the original order when it was made. So one is looking at this as at the date of the hearing before the judge. Very well established that an appellate court should be slow to interfere, and my learned friend rightly acknowledged that. I've given you the references in our skeleton. I don't think I need to take you through Spiliada and VTB. As we point out in the skeleton, there were 2 questions for the judge. Was New York an available forum for the whole of the dispute? And was it clearly or distinctly more appropriate? And on both those questions, the burden lay on GW, and the judge rejected both. In relation to whether there was an available forum, we deal with that at 71 to 74 of our skeleton. It has to be the whole of the dispute. And in paragraph 72, the judge found that there was a lack of certainty that New York would have jurisdiction over the whole of the dispute. There's no basis for interfering with that conclusion. And, sorry, I'm giving you the references to our skeleton now. Paragraph 72 of our skeleton we point
You
out
did
that...
say that.
Sorry.
That's what you said.
Yes. And 73 in our skeleton, this picks up on a point that my Lord Justice Baker raised earlier today about Lear and the attack on Lear and such like. I'm not, just to be clear, asking this court to decide who is right between Mr. Wexler and Mr. Diamond, and indeed the authorities on jurisdictional applications say that one should avoid a mini-trial. The point that we make is simply that on the US evidence there was very real doubt, as the judge ultimately found, as to whether New York would have jurisdiction to consider the whole of this claim. The most important point is the one we make in 73.3 in our skeleton, because there is a debate, in a sense the mirror image of the debate that we're having here, as to whether the New York court would have jurisdiction to consider the arguments insofar as they relate to non-US patents. And the New York lawyers were at issue on that topic. And the judge, in our submission, rightly found that there was uncertainty, that's paragraph 92 of his judgment, as that there would be jurisdiction in New York. If that's right, then the question of whether New York is more, clearly a distinctly more appropriate level arises. But if one gets to stage 2, is New York clearly or distinctly more appropriate? The judge found it wasn't, and there's simply no proper basis for interfering. As you will see from the judgment, he weighed up all the factors that were relied upon by the parties and concluded that GW had not discharged its burden. And in addition to a lack of certainty about New York, he identified the location of witnesses as a point of particular importance. And we say he was absolutely justified and right in doing so, based indeed on GW Farmer's own draft defences letter that I showed you earlier. Because, as you've seen, it places squarely in issue what happened during the research collaboration with the University of Reading in the years 2007 to 2013. And location of witnesses has been an important factor in lots of cases over the years. Indeed, it was decisive in VTB and Nutritech itself, in which the Supreme Court found that a tort claim, which it itself decided was governed by English law, should be tried in Russia, because that's where all the witnesses were. At any rate, there's been no attempt really to show an error of principle or any irrationality in the judge's weighing up of the factors. Really, the only point that has been made is that there should have been greater weight given to the fact that this is a New York law governed agreement and that there are US law issues which arise. Now we say the judge weighed that up and found that yes, it militated in favour of New York, but it didn't attract great weight in the circumstance of this case. That's at paragraph 83. The arguments can fairly be heard here. And it's a point that's actually picked up in Briggs at Authorities 2, tab 24, bundle page 874, on governing law. Page 874, middle of the page. As against this, 4 factors may weaken the argument that the identification of the governing law is a clear pointer to the appropriate forum. And the third factor is right at the bottom of the page. Third, there may be more than one legal issue to be decided. If 2 legal issues arise to which different laws apply, the persuasive strength of this factor may be reduced. And then over the page, 875, next paragraph, for these reasons, the identification of the law governing the dispute may not be as persuasive a factor pointing to the appropriateness of a court as may at first sight appear. There's reference to VTB, which I mentioned a moment ago, appearing to have reduced the significance of governing law to a factor of the if everything else is equal kind and to the decision in that case. And of course here, we're not just talking about US law, we're talking about German, Swiss, Australian and Israeli law, and indeed English law for that matter. So there's no error in the judge's reasoning. And in those circumstances, no error of principle and no irrationality has been shown. So ground 4 should likewise fail. My lady, my lords, this claim is set down for a 17-day trial in January 2024. By then, it will already have been nearly 5 years since my client first raised its royalty entitlement with GW Pharma before it has had a trial of its claim on the merits, and we say there is no basis for the English court to decline jurisdiction over that claim. Unless I can assist further.
No, thank you very much indeed.
My lady, my lords, just a few quick points by way of reply. The question was raised by your lordship as to the distinction between validity little v and validity capital V in the contractual sense. I'll just leave you with the references so that you can reflect upon them in your own time. I showed the court the prayer for relief in the New York complaint this morning. That's at supplementary bundle 11. And I would draw your attention in particular to paragraphs 132 and 139, where the distinction is clearly drawn. The same is true in the defence letter, supplementary bundle 15, at paragraphs 25 to 31 and 36. And in the defence, which my learned friend has shown you this afternoon, core bundle 12, paragraphs 79 to 82. My learned friend has taken the court through several points going to the merits and the history of the way in which the dispute has evolved. GW would, I'm sure it comes as no surprise, rebut all of them, but we do not see that as assisting the court insofar as the debate is concerned. The question here is what is truly in issue on this case, and on that my learned friend argues for a two-pronged test. First of all, the directness or principally concerned point, and secondly, the expanded contractual exception point. On the second, my lady, my lords, you will have heard what I said this morning. We say that that takes things too far and really begs the question why detailed decisions such as Chugai exist, as the argument would simply be that a contractual right is invoked, and regardless of what it may involve, it takes you outside of Mozambique. Some of the cases on the contractual exception clearly proceed on the basis that English law or a jurisdiction clause assists the court with concerns as to comity, but it is also clear on the authorities my learned friend showed you that the existence of the contractual exception, much like the question of the point at which Mozambique bites, is one of the characterization of the relevant dispute. And just by way of example only, I would ask my lady, my lord, if you would turn up Hamid again briefly at Joint Authorities 9, page 187. And the passages that I would refer the court to are in paragraphs 22 through 24. The point was made there that the contractual exception couldn't apply because the claim depended for its existence on the law of the locus of the immovable property. That's in paragraph 22. And in paragraph 23 we see the reasoning. To my mind, Mr. Stevens' pleaded case does not depend for its existence on the law of Egypt as to ownership of the property. And that, we would say, is the critical distinction. On the former element of my learned friend's test, the principally concerned point, whichever court it is that decides this case will have to deal with the invalidity defence. The royalty right arises on the basis that the relevant patents would otherwise be infringed, and much like the case that came before Mr. Justice Arnold in Annan and Molycorp, the validity of the purportedly infringed patents is inseparable from that. And that is also quite apart from the obviousness validity challenge, which we say arises independently of claim construction on the terms of the patents themselves. Very quickly, a point was taken against us that we relied on the Supreme Court decision in Blonder and related commentary to set up an argument that a decision of the English courts on Lear would be preclusive. we would invite the court in your reflection to look at paragraph 25.3 of our skeleton. That's not what we're saying at all. The point in showing you those authorities was to underline the significance of a court declaration of invalidity in the US as against all comers, as in turn relevant to the seriousness of the invalidity case that is brought for purposes of Mozambique active state public policy considerations. Finally, 2 housekeeping points. My Lord Bursu asked about Minerva this morning. We have copies of that which we can hand up to the clerks at the end of the day. And finally, toward the end of my submissions this morning, I was asked a question about opening the floodgates if the approach we had advocated on Mozambique was adopted. And at the time I submitted, I had 3 answers. I then only gave you 2. I had intended to refer you back to the submissions I had made around about 11:17 a.m. On the transcript, which is that we would say that there is a control here insofar as Mozambique is concerned, and that is in line with what Professor Briggs suggests. In other words, there needs to be a genuine dispute as to validity, which would place a control on the possibility of opening the floodgates. And indeed, after all, the European regime, which is not at all dissimilar from what we have advocated for, but which is obviously no longer in place, has put a control on these issues for a long period without there being an opening of the floodgates on validity challenges. So unless there are any questions for me, my lady, my lords, those conclude our submissions.
No, thank you very much indeed, Ms. Byrne. Thank you all very much for the written and oral submissions, which have been comprehensive and very helpful. We'll reserve judgment. You'll receive a draft in the usual way, and a draft judgment in the usual way. And it may or may not be necessary to have a further hearing.